Okay, thanks very much, Justin. And again, thanks very much for having us today. I will do a brief introduction, but I will keep it brief because time is pressing. So what or who are BEO Solutions? Well, we deal with individual employee relations issues. And what that means is, well, we could be dealing with any type of workplace mediation, be it dignity at work or whistleblowing or trust and care. And we deal with mediations as well, appeals, disciplinaries, IR issues, etc. And occasionally we are asked for expert opinions for court appearances as well. So I think that's probably enough about us.
Thank you.
Excellent. I'll jump in there then. So hi everyone, Olivia Harrington is my name. I'm delighted to be here. So as Justin said, we're going to kind of operate off a sort of question and answer structure. We find people get the most out of it when we do that. So to begin at the beginning, as people often say Bernadette, you're the employer and you've received a complaint. What do you do?
Well, I think the first thing to consider is everybody safe? So why am I asking that? Well, let's say a serious allegation is being made, let's say an assault. Is it possible it could happen again? Do you need to put somebody on leave, paid leave? So that's the first thing. Are you still able to provide a safe working environment for your employees? So then I suppose the next thing to look at is the complaint itself. And at this stage, I just want to take a minute to think, well, you have this complaint. What are the other things, let's say a HR manager in a large organization would do next? Well, they might consider, well, first of all, is it really, does it really need to be investigated? And I think it takes a very brave person to say, no, I'm not going to investigate that. When a complainant has gone to the bother of sitting down and writing it, clearly they feel strongly about it for one reason or another. Can you identify, though, what it is they're complaining about and what policy you're going to have to use to address it? And this is where having policies becomes really important, because you do need to be able to distinguish between grievances, dignity at work stuff, harassment, etc., and all of those other things. And sometimes they can be a bit muddled. So I know we're looking today primarily at bullying, harassment, and sexual harassment. So we're going to stick with that going forward. The next thing then is to think about, well, you know, how long might this process be for you in your organization? So again, if you are in an ideal world where you had sufficient people to deal with all the stages, so you could have your investigation, you may then have to deal with an appeal, you may then have to deal with disciplinary action, a disciplinary hearing, you might have to deal with a further appeal, etc. There may be a dismissal. Who knows? And the question I'm putting to you now is, well, who's going to manage all of that and who is going to perform all of those different tasks? And identifying a sort of a plan or structure in your mind at the start is really, really useful. So again, treat one bit of advice is just from the very start, treat both parties the same. And sometimes in a small practice or even in a larger one, you might have a situation where you're more friendly with one than the other. But when you're in this role, you must be impartial, because later on, who knows, in a third party forum, your emails to one could be compared to your emails to another, or letters, and they may not be the same. So it's just important to bear that in mind. Don't, for example, go to lunch or coffee with one and not the other. It's, you know, and certainly don't, once a process has begun. You might do that, for example, if you wanted to discuss mediation or something like an informal resolution. And I suppose that takes us to our next question, Olivia.
Absolutely. It's very interesting what you're saying. And I think people don't often realize they need to be aware that there's an issue with actual and apparent bias. So that's something to always bear in mind. So once you've kind of dealt with those preliminary considerations, and there are so many of them and they're very important, what do you do next?
Well, again, I think it's important to emphasize that informal resolution, in my view, is always going to be better. You have a better chance of making sure that the relationships are maintained to a sufficient standard to work effectively together. So next thing then, are the allegations amenable to informal resolution? And what might that look like? Well, obviously, mediation is the one that springs to everybody's mind. And if you have somebody in-house who's trained in mediation, then absolutely, that's great. Use them. I mean, you offer it to the parties. You cannot force them, as you know, it's obviously voluntary. So quite often, certainly with sexual harassment, people are less inclined to take the informal route. They're much more inclined to go straight to formal, and quite often don't even want to be in the same room as the person they're accusing. So those are things that may need to be managed. But again, you offer it to them, and if you're going to appoint a mediator, I think it's best. And obviously a senior manager can hold a robust conversation with people, but often sometimes that just beds the problem down even more. So a bit of training is really, really useful. And I suppose, don't forget, there is no guarantee of success with mediation. So you may still, even having gone down that route, still find yourself back at the start. So over to you, Olivia.
Absolutely. And I think with mediation, there's often a much better result at the end of the day if it is successful, as against an investigation, which is really always very divisive and time consuming, amongst other things. So there was a new code of practice on bullying, and I realize I'm calling it new. It was from early last year, so it's not so new anymore. And it created these concepts, so not a new concept of the contact person, but perhaps the new concept of the nominated person. So will you tell us a bit about those rules?
Yeah, so very briefly, a contact person would be somebody, generally speaking, that you could go to if you thought you were being bullied or harassed, and they could give you the information you might need to help you make a better informed decision. Now, the point about that is that that's really useful for helping people who are just being managed robustly to understand, well, maybe it's not bullying, maybe I need to up my game here. And sometimes it can help manage that side of things. The nominated person is very different. It's a new concept, and I haven't seen it in action yet. And essentially what it does is it has a senior manager look at the situation, more or less reach conclusions, and then work to the resolution with both parties. So it's kind of like an informal investigation. So we're all kind of waiting to see how that's going to work.
Yeah, absolutely. I think that concept of a nominated person kind of reaching a decision but not really is kind of dangerous territory. So we are kind of looking at that in anticipation. So essentially then you'd have a structure to address the complaint that's come in. So maybe you've tried mediation, it's failed, or it's worked, happy days. But in this case, let's just assume it's failed or been rejected and it hasn't resolved the issue. So what then are the first steps that you take in an investigation?
Okay, so first things first, you have to decide who's going to do the investigation. And this is really important that these people are trained. For example, I had a case recently where a very senior manager in a public service setting did an investigation and decided that, well, I think there's room for doubt here, and I think the respondent should be given the benefit of the doubt. And he did not uphold, or didn't feel that the complaint was established. Now, of course, that's him applying the standard of proof for criminal cases, the beyond reasonable doubt, whereas what should have been applied is the balance of probabilities. So again, just to avoid making mistakes like that, it's best to have the training. Then you need to draft terms of reference. These are hugely important, and getting them right can be really, really difficult. They're different for each type of investigation, but essentially what they'll do is they'll set out the who, the what, the when. So who's going to do the investigation, who is the complainant, who's the respondent, what stages or steps are going to be in the investigation, and how it's all going to work. And more importantly, which policy it's going to be done in accordance with. So then, don't forget, at that point, the investigator has full capture of the case then. In other words, there should be no interference, they should operate independently and impartially. Olivia.
Okay, so then taking a kind of standard investigation of bullying, and I say that with a smile because I don't think there ever is a standard investigation into bullying, but how might that investigation run? Okay,
so first things first, let's say it's bullying or harassment. And we would normally meet the complainant first. We take their record. We ask them, do they have we ask them to describe the thing in their own words. So we take their narrative first, and then we funnel down into questions that to give more precise detail, to clarify things. And once that's complete, then we create that record of interview. We actually record our interviews, so we can discuss that later if anybody needs to know more about that. So that record then is shared with the respondent. They're given some time to think about it, and then we meet with them and we do exactly the same. We take their version, we funnel down on the questions, and we make their record of interview as well. That is then shared with the complainant, who is allowed an opportunity to comment. We don't need to hear it all again. We just need them to comment on things that are new or different that they disagree with. And then we meet the witnesses, and we do the same with them. We take their records of interview, and each one of those will sign off, hopefully, on their interview. And then that's shared with both parties, who have an opportunity to comment. And at that point, sounds very short and sweet, doesn't it? But at that point, the investigator can begin to draft the report and arrive at their conclusions. Now, it's important to note that both the new codes of practice talk about investigators not upholding, so don't use the word uphold. You could say that the allegation is the complainant has established that the incident occurred and that the behaviour occurred. And that's important. In the bullying one, it talks about being able to say that the behaviour alleged has actually occurred. So if they're alleging bullying, it's okay to say, I think, that and if it's established that bullying has occurred. So that's really it. I think, yeah.
Briefly, just you mentioned funnel questions or funneling your questions down. You might just explain that.
Sure, yeah, that's a thing that actually comes up in marketing. So say you go in to buy a computer and you say to some, or a laptop, I want to buy a laptop. The first thing they'll say, well, what do you use it for? And they'll get you to describe all of that. So you have this open question, tell me all about, what do you use it? And then they'll say, well, would you need this? Would you need that? So you can see this as wide open question. Then we're coming into more focused questions. And eventually, actually, you might even have to ask, so have I understood correctly? It's this and not that you're talking about, and you get them to confirm. So you really have it pinned down. And for each incident, so let's say there's been an incident every Monday for the last 5 weeks, you'd go to the next Monday then, and you'd start with your wide open question and come down, and then the next one, and that's how it works.
Right. Okay, so you're the investigator, you've gone through all of the steps, you've met with everybody, you've written your report, and now it's been issued to the employer, I suppose. What sort of things should the employer be looking out for? Okay,
well, I think the employer then would have to content themselves that they accept the findings of the report. And the reason I say that is because, remember, the codes of practice say now the investigator is not the one upholding it. They're saying, I think it happened. It's the employer representative, whoever that is, who is saying now, yes, okay, I accept this happened. I accept this report. So they need to content themselves that the complaint that was made has in fact been addressed. They need to content themselves that the decision reached is reasonable based on the information they have, not to impose their own decision, but just to check that it is reasonable and not perverse. And then you have to decide, well, what action is necessary. So if it's established that it did happen and you've accepted it, what next? Is it disciplinary action? Whatever. Generally speaking, you'd write to the parties at this point and say, here's the report, or here's the result sometimes if they don't want to share it. And say you have an opportunity to appeal. That has to be in with us by X date, and your appeal letter should indicate what exactly it is you're appealing and why. So that would be the next step then, and then a decision on what happens next.
Great, yeah, exactly. So I suppose the question would be, have you actually reached the end of the investigation once you've gotten the report? And the answer is maybe, and it's kind of out of your hands, isn't it? So it depends on the policy and the parties and everything. So what would, say they do go for an appeal and there's a provision in the policy document for it, what would an appeal process look like?
Well, again, depends on the policy. So don't forget, your policy is your rule book, and they're entitled, the parties are entitled to rely on it. So if you step out of the policy, you're just going off doing your own thing. You must stick with your policy, hence why it's so important to get them right. So usually an investigation appeal considers, again, the things I've said, whether the proper process has been followed, whether fair procedures were given, although I think the legislation says you don't need to do it at investigation stage, but I'd rather just do it all the way through. It should correct any deficiencies in the initial investigation process. And so therefore, if just, inappropriate procedures were used, or somebody failed to engage with a particular witness or something like that, then that should be remedied at that point. And then the appeals officer will find themselves having to reconsider everything on the totality of the evidence and arrive at a conclusion. If it doesn't correct the deficiencies, then what it might do is sometimes, and again, depends on the policy, it might refer it back to a new investigation, but then it has to be a new investigator. So that's much more bothersome.
Okay. So then say you've reached the end of the investigation, you have the report, perhaps there has been an appeal and there's been a finding of inappropriate behavior. So they've effectively upheld the allegation of bullying. So and the employer, the person who's received it, is happy to accept that finding as well. What happens next?
Yeah, okay, well then let's say it is upheld, and so disciplinary action then has to take place. And do you have to do that? No, I think it's still better if you have someone else who can do it. You'll remember, as I mentioned at the start, you're the one setting up the structure and you're orchestrating, if you like, the various stages in the process. And in any event, it's important to keep somebody senior for the final decision that may or may not need to be taken. So at this point then, best practice suggests that a disciplinary hearing take place. Again, this is not a reinvestigation. This is simply to put the allegations to the person and ask them if there are any, their findings now actually, put them to the person and ask them if there are any mitigating circumstances that might need to be taken account of, and then go away and consider that and issue a decision.
Sorry, continue.
No, that's fine. It's just that it's, again, keep in mind who's going to do the appeal and who's going to be the ultimate decision maker.
And at that sort of disciplinary hearing stage, that's sort of when you'd expect representatives to filter in for people, isn't it? I mean, they can come sooner, but you might often see a solicitor or a barrister attending with individuals in those settings.
Certainly, if you're in the environment where the allegations are serious enough to be, to possibly lead to a dismissal, then yeah, I think that's becoming more and more common. And again, if it is a very serious allegation, why not let them in? I mean, my own view is when say solicitors arrive as the support person for an investigation, I have no difficulty with that because their role on that day is the support person, right? And it's quite different. However, when they do arrive for the disciplinary hearing, I would always give them an opportunity to present what points they wanted to make, whether there were legal points, whether there were, and indeed, at that point, you may well have to provide them with an opportunity to cross-examine.
Yes,
people who have been previously involved. So this, if you like, disciplinary hearing can become quite a tense affair.
Indeed, it can mushroom into more than you ever expected. Okay, so then that's the end of the disciplinary hearing. You think you have a conclusion, but is that actually the end of it?
Well, no, not necessarily. Yes, it could be. It's like your answer earlier, maybe. So it depends. If one or other of the parties has an appetite to do so, they can, of course, go to a third party forum, usually the WRC, but on occasion it can be the courts. So it could go on there. And bear in mind, so from the start of your process, I would always suggest that you run it and build it in a way that you would be perfectly comfortable with being read out in the High Court. And I think that's a good advice.
I think that's a brilliant rule of thumb, actually, for anything to do with these issues, because of course, if you write an email and it's read out in the High Court, you might have phrased it differently before that. All right, well, that's the end of my questions. So I suppose now is the time to turn over to anyone else's questions for us.
So
Sure.
There is a couple of questions there
Great.
in on the chat. So at what stage do you give a copy of the complaint to the person against whom the allegations are being made? And just going back to what you just previously said, do you wait till the finding has been made, or is it a couple of days after it's been received?
So you have that time. So I suppose more haste, less speed is really what's important at those initial stages. So this may come completely out of the blue for you as the manager, right? And you've no idea any of this is going on. And it may well be that the complainant is suggesting that it's going on a couple of years. So it just takes time to consider what you need to do. You may need to secure some evidence, such as CCTV footage that will be lost if you leave it until the investigation begins. When do you give them a copy? So once you've those initial considerations done, and I think then they should be given the complaint. I think they should be given it quite early, as soon as possible, really.
Absolutely. You don't want to get to the point where you've agreed an investigator, a set of terms of reference, you've told the complainant, and then suddenly it's a surprise to the respondent. I think people wouldn't feel very good about that, and I can understand why. So early doors, I think, yeah, absolutely.
So the second part of that question was, does that not lead to just general relationship breakdown between the two parties? Regardless, yeah.
Once a complaint is made, so no, at that point it may seem irretrievable, and I've certainly been asked to mediate situations that they said, look, and to be quite honest, the HR person might have said to me, we're doing this so as we have a record of it that we did it. Right? They may not always be terribly optimistic, but in fact, I'm actually dealing with a mediation at the moment where the complainant lodged a complaint and it was investigated, and the results are available to both of the parties now, and I'm mediating that with a view to restoring relations to at least being effective at work. And I'm very optimistic that it's going to work out. So I think, again, it's a question of what might seem. See, sometimes these people really just want the whole thing to be finished. The person made the complaint and they've been justified or whatever, or they've had their proper explanation. Now they're in a whole world of pain. So is the respondent. And sometimes at that stage, it's that you can use to work and with a mediation. But a situation like that certainly calls for a bit more experience in the mediator, I would say.
So just taking a step back, just right back to the start on the policy setting within the practice, and whose role, and just to draw attention to the new code of practice that's out there, where would I find that? But maybe I'll just continue on my question, then you can answer it. Whose job is it to set the policy within a very small firm? Is it the HR function, if there is one, or is it some outside party? And then the investigation piece, is that to be done by the principal of the legal firm? A few questions there.
Yeah, that's okay. Well, I'll give you my view, and I'm sure Olivia will give you hers in a minute. But to me, the employer is responsible, right? The employer is responsible under a variety of acts for creating or for maintaining a safe place to work under the Safety, Health and Welfare at Work Act. And be in no doubt now that the latest 2020 code says that bullying is a safety at work issue, all right? And so does the Employment Equality Act. They all place the duty of care with the employer. So ultimately it's the employer that's responsible. And I would assume whoever is in charge or managing that practice then is the person who should make sure somebody somewhere is doing this. So if we were asked to do an investigation and they have no policies, well, we'll revert then and use the codes of practice, right? In terms of applying best practice for the investigation bit. But it will mean that the employer has sort of lost out on all of the other benefits. And certainly it's really important to know that for harassment and sexual harassment, if you don't have a policy, you're very unlikely to be able to avail of the defence under the Act, Section 14A. So it's really important that the employer is responsible. Who they decide or who they allocate it to is a matter for them.
Yeah, absolutely. And depending on the size of the organization, if they do have a HR function, all the better, because they'd usually be responsible for either writing it or finding one anyway, obtaining one. And then management might sign off and say, perhaps you might change this, you might change that. But if there is no HR function, and perhaps you don't have an outside HR function, then it is up to the senior managers to make sure there's something in place. As Bernadette said, if there isn't a policy in place, so be it, and you can work around it, but it is better to have one. It makes things much easier when these issues actually do arise.
And the reason it's important then to make sure that you get it right when you're doing the policy is because, as I said earlier, that becomes the rule book then that people will use against you if it's not done properly.
And then as part of that, you made reference to training or getting particular types of training. Is this training in putting together a policy or training in the actual investigation piece, or both?
Well, I don't know of any training to draft a policy, but a lot of the HR people, network together and they have a lot of this kind of squared off, if you like. No, the training that maybe there is training though out there and I just don't know about it. The training I was talking about was, I think it's very important for the individuals conducting each stage of the process to know what they're doing and to know what is the correct way to do it. But also I think for that person, that manager that I said is the conductor who's managing all of that. Now in a large firm, that would be somebody in HR, probably somebody relatively senior. But whoever it is, they need to know what the next step is and they need to be familiar with their policy, because again, so many of the cases going to the WRC in relation to this are to do with like you didn't even stick to your own policy. So that's really important. I think also it's important to note that bullying can still go to the WRC now under the IR legislation as well. So just bear that in mind too.
I think it's important to be aware, I suppose, that any number of things go wrong with one of these investigations, and we've experienced most of them, unfortunately. So that's why we suggest training, because at literally any stage, something could arise that you're not familiar with or you're not quite sure how to deal with. And you think, the concepts of fair procedures would sort of dictate what you should do, but they don't always. It's not always an obvious answer. So Bernadette, if you give her enough time, might actually give you some of those stories of the things that we've dealt with.
I think the war stories will have to wait for another day, Justin. I think we're nearly out of time, are we?
Yeah, so we're coming up to the last minute. If anyone had any final question, we possibly could quickly take it. But in summary, Bernadette or Olivia, did you want to just give some final tips to people on what they should do or might do, or
have a policy and have a plan? If I was asked to do it in short, that's what I would say.
Absolutely. Have a plan and be fair. So put yourself in the shoes of both parties.
So thank you very much, Bernadette and Olivia, for joining us today from BO Solutions. Next week, we're covering cessations, closing down or winding up a practice, what you need to know. And that's with Liam Barrett from the Regulation Department. And on the 15th of June, we're learning more about TrialView, a digital dispute resolution solution. And on the 22nd of June, I'm joined by Michelle Nolan, who's going to discuss Women in Leadership Mentoring Program. Thank you again, everybody, for joining us today on this very important subject matter, dignity matters, and how to deal with a complaint. So thank you very much, Bernadette and Olivia from BO Solutions. Thanks for joining us today. We'll send out a recording later in the week, and hopefully you'll join us next week. Thanks, everyone.
Thank you.
Thanks, guys.
Thanks, Justin.
Thank you.
See you again sometime. Bye.